All right, today we're going to be discussing no equal justice. They got it in really itty bitty words, so bear with me. I gotta use my spider vision to be able to read it. Race and class in the American criminal justice system. Just joking, it wasn't that small. This is by David Cole. Let's see what year. We're talking 1999, so at least we're in this, kind of, not in the 2000s yet, but, so half the world was alive when he wrote this, give or take. Millennials are like zero. Let's see, here goes a nice little quote. There can be no equal justice where the kind of trial a man gets depends on the amount of money he has. I like that. The reason I like that, because I thought we were talking about race and things, but he put in the class, which was great. I like that. That was awesome. All right, we got introduction. We got policing the race and class, a muted trumpet, judgment and discrimination, the color of punishment, see no evil, hear no evil, the cost of inequality, remedies. All right, so I got policing class. Sorry about that. Policing race and class. That's interesting to me. And then the other one is see no evil and hear no evil. And speak no evil. It doesn't say speak no evil. So I guess we're going to see the evil. We're going to hear the evil. Well, I'm going to see the evil. You guys are going to hear the evil. And I'm going to speak it. You get it? I'm going to see it and speak it. You're going to hear it. 158. Someone put a little tab in here. I want to see what this is. What is this? Nothing important. Yeah, that's great. Now I just made a mess. 148, is that what it was? 158, excuse me. All right. See no evil, hear no evil. In April 92, federal and state agents on a joint drug crime task force raided room 203 of La Mirage, a seedy motel in Los Angeles, and arrested Christopher Lee Armstrong and four of his companions. That month, a federal grand jury in Los Angeles indicted the men for conspiracy to distribute more than 50 grams of crack cocaine. All 5 were black. To the public defenders who were assigned to represent the men, the pattern was all too familiar. On the 24-hour crack cocaine case, the public defender office closed in the prior year. All the defendants were black. And of the 53 crack cases the office completed over the prior 3 years, 48 defendants were black, 5 Hispanic, and none white. At the same time, they knew that many whites used crack, that white defendants had been tried for crack cocaine charges in California state court system, where the penalties are much less harsh. Armstrong's lawyers suspected that the authorities might be routing black defendants through the federal system. Right? Are we catching this? So not a single white person was arrested. We only had 5 Hispanics. So, not a single light person, right? Hispanics can be dark, but they're not quite as dark as we are. So I say light. So it's not to say white. While directing white defendants into the more lenient state court system, if prosecutors were treating defendants differently based on their race, they reasoned that conduct would violate equal protection and should require dismissal of the cases. However, the best evidence of what the prosecutors were doing and why they were doing it was in the prosecutor's control. So the defense lawyers submitted to the court the evidence of racial disparity that they had and asked for the right to conduct discovery on the prosecution's file to determine whether their suspicions were in fact well-founded. That's kind of interesting. In making selective prosecution, in making their charge of selective persecution, Armstrong's lawyers We're not advancing a new theory. The Supreme Court had recognized long before the selective enforcement of the laws based on race violates equal protection. In Yik Wo versus Hopkins, the court in 1886 unanimously overturned convictions of 2 Chinese men for operating laundries without a license. Interesting. San Francisco authorities had arrested about 150 people for operating laundries without a license, every one of them Chinese. They had denied licenses. They had denied licenses to all Chinese applicants, and they had granted licenses to all but one of the 80 or so non-Chinese laundry operators who applied. In a unanimous decision invalidating Vic Wo's conviction, the Supreme Court stated, though the law itself be fair on its face and impartial in appearance, yet if it is applied and administered by public authority with an evil eye and an unequal hand, so as practically to make unjust and illegal discriminations between persons in similar circumstances material to their rights. The denial of equal justice is still within the prohibition of the Constitution. I don't know if this is any interesting to you, but this is pretty interesting. I don't want to go too far into it because it's just going to keep on going into different cases. But this is quite interesting. See no evil, hear no evil. All right. So I'm guessing the reason we're not seeing it because it's if someone gets in trouble, they go to trouble. Right. So we're not seeing it because we're not specifying it as like the public eye. We're not hearing about it because they're criminals. Right. And then no one's talking about it because no one cares. But this is, it literally is telling everybody that, what is it? Jim Crow, equal but not, or what did he say? Equal but not the same. All right. If I wasn't trying to say it right now, I would have easily been able to say it. But now I'm put on the spot. I can't think about what it is. Equal but opposite or something like that. It's the same thing right here, what they're discussing in See No Evil, Hear No Evil. So this is a great book. What I'm probably going to have to do is read this whole thing. This is amazing. Because if I've already learned a little bit in that first little bit, I wanted to policing race and class. Because when we're discussing like class of Americans, then we take the race out of it. That's why I'm very interested to see what they're saying. Because if it's just, it's way too easy to hide everything with race, right? That's a metric that is so easy, right? Because, one type of people have darker skin, one people have lighter skin, right? Dark, light. But when you're talking about class, it's very different, right? Because now you're dealing with the police that are the same color as the people. And 9 out of 10, they're in the same class as the people they're policing. However, they're being paid by a different class of people, right? Does that make sense? So that one would be really interesting. If you think it'd be interesting too, let me know. And I'll go in, because I'm interested in this. I don't know, maybe you're not. Anyways, have a great day.